Hello everyone, welcome to my channel. My name is Ronnie George and today we are going to discuss about the patent registration procedure in India. At the end of this session, one will have an idea about the steps one should take right from filing the patent application up to the patent grant. So without wasting any time, let's jump right to the topic. So the process of patent registration starts with filing of the patent application. Now, as per the Indian Patent Office, there are two ways to file patent application. One is the provisional application and other is the complete application. Now, let's understand what is the difference between provisional application and a complete application. So, provisional application is basically an option provided by the Indian Patent Office in case the application or the invention is at a very initial stage, right? So what I mean is, let's say there is an inventor or there is a person who came across a problem and thinking about the problem, he found a solution, which is basically an invention. Now the person has an option because since it's such an initial stage, the person has one option that he can work on his invention, do some experimentations, and then find out whether that invention is a good invention or not, and after that he can decide to file a patent application, right? But the problem with such an approach is, the time he would spend in experimenting and conducting research. In that time it may be possible that someone else, who would come up with the same invention, maybe in any other part of the world, that person or that company can file the patent application in that meantime, and then this person, the first person, will lose his chance of getting a patent application, a patent on his invention, right? Because he spent that amount of time in researching and experimenting. So just because that should not happen, the patent office has provided an option that one can file a provisional application. Now the provisional application is like, is basically fine to get is filed to receive a priority date. Now, what I mean by priority date is, like, let me give you an example. So if I have an invention which I want to protect, now if I file it, let's say tomorrow, okay, and tomorrow the date is um, June 1st, 2023. So I will get that date, okay, that date is known as the priority date. Now anyone who is filing the same invention after this date, I don't have a problem because I have the priority date before him, and so I have all the all the rights over my invention, and that person or that application filed by the other person is not a problem for me. So that is one option when one wants to file an application. If the invention is at a very initial stage, they can file a provisional application. So once they file a provisional application, they will have a period of 12 months. Okay, and in that 12 months, they can do some research, they can do experimentation, they can find out, okay, how the invention which they thought at the initial stage can be further improved. And by the end of the 12-month period, like still within the 12-month period, they can file a complete application which will include the entire detail of that invention. So this is one approach. Okay, now let's imagine another scenario where the inventor, whether it's a person or whether it's a business or a company, had already worked on the invention. Okay, they already have the complete details of the invention, and then they decide to file a patent application. So, at this point, they don't need to file a provisional application because they already have all the details. So what they can do is they can directly file a complete application at the Indian Patent Office, and then that application will be taken forward. So these are two options. If the initial invention is at a very initial stage, one can file a provisional application, and then within 12 months, one can file a complete application. there is no restriction in the 12-month period. So if someone wants, they can file even after a month of filing a provisional application, or they can file at the last date of the 12-month application. So there's no restriction or no such rules in that date. Okay, so now there is also a difference between provisional and complete application draft. I mean draft as in what document they are filing. So there is a difference. The difference is basically provisional application will not contain a section called claims, and claims forms the most important part of a patent document. It basically shows what protection, or what is the scope of protection of the invention. And while filing a complete application, it is very important to include the claim section. Without that, the application is of no use, right? So now let's imagine if someone had filed a provisional application first and then filed a complete application. So in that case, their priority date will be from the provisional application date. And in the other scenario, if someone had directly filed a complete application, then their priority date will be the date on which the complete application is filed. Now, this is the filing stage. This is the first stage of a patent registration procedure. The second step is the publication. Now, what does publication mean? So, when a patent application is filed in the patent office, the patent application is kept hidden for a period of 18 months, okay, from the priority date. So what that means is, once a patent application has been filed, no one will, even not even the applicant can see the application that they have filed for the first 18 months. Only after the 18-month period is over, the patent office publishes this application in the patent office website, or in case of Indian patent office, in the Indian patent office portal, they publish it. Now, once they publish it, anyone can see it, because once you are filing the application, you will get an application number, and based on the application number, you can see your application in the portal of Indian patent office. So your application is published. Now, if it was filed a provisional, then 18 months from provisional. If complete was directly filed, then 18 months from complete application. Now your application is published. Now there is also one more option by the Indian Patent Office, and that is filing, the publishing your application at an earlier stage. So that is known as early publication. So as I said, in the normal route, there will be a 18 months period. After that, the application gets published. But in some cases, the inventors, they want to get their patent application granted quickly, right? So they don't want to wait for the 18-month period. So they have an option where they can file a form which is known as Form 9, known as early publication form. They can file it, and once they file it, the application usually gets published in a period of 1 month. So a lot of individuals, inventors, or companies, they file the early publication form along with the complete application. So when they do that, the application gets published in a period of 1 month. Now, okay, the application has been published. Now what? Well, the next step is request for examination. Now let's understand what does request for examination mean. So it's basically a form which is Form 18 as per the Indian Patent Act. So when an application is filed, it will remain in the patent office, and the examiner who is sitting in the patent office will not examine that application unless and until the Form 18 or the request for examination is filed. So only after this form is filed, the patent examiner will examine the application. So it's very important to file this application. If this application is not filed, it will be considered that the application is abandoned, or it has, okay, yeah. So request for examination can be filed anytime within 48 months from the date of priority. So if I had filed an application, provisional application June 2023, I will have 48 months, which is like 4 years, to file the request for examination. So I can file it along with the application also, along with the complete application also, or I can wait till the like 48 months period, and then I can even file when the end date. So that depends on the inventor, the applicant who is filing the application. If they are in a hurry to receive patent grant, they can file it as quickly as possible, and if they are in no hurry, they are okay with the application getting delayed, they can wait till 48 months period. There is no restriction. But yes, you cannot miss the 48 months deadline, because once that is gone, the application will be abandoned. Okay, so this is the request for examination for the normal route. Now in request for examination also, there is a category which is known as expedited examination. For that, one has to file form 18A, and as per that, once someone files an expedited examination, the process of examining the application gets faster. So the examiner will take the application much faster in comparison to someone who has just filed a normal request for examination form. So again, this is also one of the facility provided by the Indian Patent Office to expedite the process of getting patent grant. Now, yeah, so very important point here is to understand that this facility of expedited examination is not eligible for every applicant. There are certain applicants who fall under this category, and only those applicants are eligible to file an expedited examination form, that is form 18. So you can get the data about who are eligible online. If you conduct a search, you will get an idea. So okay, so once an examination request for examination form is filed, the next step is uh, the issuance of a first examination report. Okay, so this is basically a report which is issued by the patent office, and this report basically contains a list of objections which the examiner feel is appropriate with respect to the application once an applicant has filed. Like now what it includes, I will just give you an idea. So there are basically two types of objections. One is the formal objections and one is the informal objections. So the informal objections basically include patent references or non-patent literatures that may be similar to your invention. Okay, so let's say if I have filed an application with respect to car headlights. Okay, my invention is in the field of car headlights. Now if I have file an application, what the examiner will do is, once I have filed the request for examination, the examiner will pick my application and will conduct a search, and he will find some references which according to the applicant examiner is similar to what my invention is. So so he or she, the examiner, might find some references related to car headlight which according to the examiner is similar, and the examiner will add those references in the examination report, and based on that the examiner will also give a statement that whether my invention surpasses novelty or inventive step or industrial applicability in that case. These are the informal objections. Now there are also formal objections, which is basically the the signature. If I have provided the signature properly, if I have followed all the rules of a patent application, the title, the sections, abstract, summary, if I have added that, if I have written the claims properly. So this is basically these are basically the sections which are there in a patent document. I will publish another session which will cover the anatomy of a patent application. So these come in the formal objections. I have paid the appropriate fees or not. So these kind of, so this first examination report that the examiner will issue will include both these informal and formal objections, and he will share it with the applicant, right? So at this stage, you will receive an examination, first examination report, and where all the objections will be stated. Now what will happen? Now once you get this examination report, from that date up to 6 months, you have the time to submit a response to the examination report, which is known as a response, a first examination report response. Okay, so in this response, what you do is you take each of the objection which the examiner has submitted, and you prepare a proper response to it. Like as I said, the informal objections will include patent references which according to the examiner is similar to your invention. So what you have to do is you have to read those patent applications or those patents which the examiner has cited, and you have to understand, are those references exactly talking about your invention? Well, if there is a difference, then a response has to be drafted in such a way where you are properly differentiating your invention with those references, and you are stating that why your invention is still unique and why a patent should be granted on it. Similarly, for the formal objections also, you have an option to write a response to each of the formal objection and submit your response, making it clear that either you have followed all the actions which were required to be taken to correct those formal objections, and in case those objections were stated wrong by the examiner, then you can also respond to it saying that these objections are not valid because of so and so reason. So you file a response to it. Now once you file a response, two things can happen. One is the examiner gets convinced by your response, and if he or she is convinced by the response, they can simply grant your application. Okay, in that case, you will get a notification saying that your application has been granted, and you will get a patent grant number, and you will have a granted patent in your name, which directly jumps to the grant or refuse stage, as I've shown in this slide. The other scenario is, let's say the patent examiner is still not convinced. Okay, you have provided a response, the examiner has gone through that response, but the examiner is still not convinced. Now here also there are two things that can happen. One is the examiner can issue a second examination report stating that why stating all the objections which according to the examiner is still relevant, and he or she has not received a proper response to it. That is one scenario that can happen. If such a scenario happens, then again the same process will happen. The applicant has to file a response to the second examination report. The other scenario is, which happens in most cases, is the examiner issues a hearing notice. Okay, now what is a hearing notice? So hearing notice is basically a video conferencing session between the examiner and the applicant. In case the applicant is processing the application through an agent, a patent agent or a patent attorney, then in that case the patent agent or attorney goes on a video conference or hearing with the examiner. So hearing notice will basically contain the objections where the examiner is still not convinced, and it will also contain a date and time for the hearing session. So once that is received, the next step is to attend the hearing. So in the hearing, either the applicant can attend it himself, or if the applicant is processing the patent application with through a patent agent or a patent attorney, the patent agent or attorney can attend the hearing on the behalf of the applicant. So in that session, what happens is the patent agent who is attending, or the applicant, if in case he is attending directly, they have a face-to-face conversation, and they try to explain the examiner about the references, like what are the references, what is their invention, and how it is different, and about all the formal objections and how they have taken the steps to overcome or to correct those formal objections. So this is what happens in a hearing session. Now once the hearing session is completed, now in the hearing session both of them share their views. The examiner may ask questions to the applicant or the agent about the queries they would have, and the applicant or agent has to make sure that they satisfactorily reply to the answers or to the queries of the examiner. Now once the hearing is conducted, there is a process of submitting a written submission. In this case, whatever the discussion happened in the hearing, that has to be submitted within 15 days of the hearing, and it has to be submitted by the applicant. So the applicant will, prepare a written submission, or the agent can also prepare the written submission, and they submit it at the Indian Patent Office, uh, and to the examiner. And once that happens, in a specific time, although the time is not defined, the examiner, the patent office or the examiner will let the applicant know whether the patent application has been granted or it has been rejected. So if it's granted, again, as I said earlier, if it's granted, the applicant will receive a patent grant number, and then he will also receive a patent grant certificate, based on which it's a proof that the application has been now granted. If it is refused, then there is another option of taking it forward in some other way, which I'll explain in the late another session. So let's understand if the application is granted. Now, once the application is granted, then the annuity payment period starts. So a patent application is usually lasts for a period of 20 years. So that is the lifetime of a patent. So once a patent is granted, 20 years from the date of filing the patent application, the patent is valid. Once the 20 period is over, it is said that patent is expired and it falls in the public domain and anyone is free to use it. So for those 20 years, there is an annuity payment defined by the Indian Patent Office. You can get the details of it online or in the Indian Patent Act. So as per that, every year, depending on whether you are a startup or a small company, a small or medium enterprise, or whether you are a part of a large company, or whether you are an individual. So based on that, fees are defined. So accordingly, like each year, there is a certain fee that one has to pay in order to keep the patent alive. So only if you are paying that, that amount yearly, the patent will be kept alive for 20 years. And once that 20 years over, the patent is, actually expired and falls in the public domain. So this is basically the process of patent registration in India. And so I hope the process of patent registration is now clear. If there are any doubts, please feel free to ask me in the comments, and then I can reply to you. So that was it. We'll meet again with the next topic and discuss more on the IP and patent related matters. Thank you, everyone.